Happy Thursday. Welcome to session 35, take two. This is the second of three that we're doing on using financial aid information for program evaluation and research. I'm Michael Hawes. I'm Director of Student Privacy Policy at the U.S. Department of Education. I'm joined by my colleague Benjamin Ferraro from my office. We are in the Office of the Chief Privacy Officer at the Maine Department of Ed. And my division is responsible for administering FERPA, the Family Educational Rights and Privacy Act, developing policy and guidance relating to FERPA, student privacy more broadly, and also providing technical assistance to the broader education community on compliance with student privacy laws and privacy and security best practices. This includes our Privacy Technical Assistance Center, or PTAC. Quick show of hands, how many of you are familiar with PTAC or have used PTAC resources before? Okay, about half of you. For the rest of you, I'm going to include some information at the end of our presentation today about how you can access the PTAC resources. There's a lot of really useful information there, and so I do highly recommend you check it out. So what are we going to do today? How many of you came to one of the sessions that Ben and I did at last year's conference? So a few of you. Okay, so just for those of you who weren't here, at last year's conference, this was really kind of our first foray into trying to answer some of the questions that arise at the intersection of the numerous federal laws that apply to students' financial aid information. As Ben will talk about in a few minutes, those include FERPA, which I mentioned before, the Higher Education Act, the Privacy Act, and then various provisions included in your agreements that your institutions have signed with the Department of Ed. Because there are so many of these laws that apply in the context of financial aid information, many of the questions relating to data use and data disclosure become very complicated very quickly. So at last year's session, we walked through a few answers to those questions. We walked through what the laws meant and how they applied in a few scenarios. And then we heard a number of questions from you and your colleagues here that we didn't have answers to. But that we took back with us, and we kind of worked through many of those, and between what we presented and the questions that we heard from you that we were able to answer, we then published in January of this year the guidance document that I have the link for in the slides, guidance on the use of financial aid information for program evaluation and research. That is not a comprehensive document. It doesn't answer all of the questions in this issue space, but it answers some of the big ones and some of the most pressing ones that we heard at last year's conference. This year, I'm going to walk through, well, Ben and I are going to walk through the content of this guidance document, and then talk about some of the new issues that have arisen, and then mostly we want to hear what questions you have currently. So we're going to save a fair amount of time at the end to hear your questions. We got a large number of them yesterday. Some of them will probably be the same as the questions you have. But I'm going to caveat in advance, because of the complexities, because of the legal complexities involved at the intersection of multiple federal laws, I probably won't have answers today for many of your questions that you're going to raise during the Q&A. But rest assured, much like we did last year, we are going to be taking note of all of your questions, and we are going to be working through those questions and providing answers, and we hope to do a new iteration of this guidance document in the not-too-distant future that incorporates answers to any questions that we can't get to today. So what are we going to cover? We're going to talk about the different types of financial aid information that you hold, that come to us and in other contexts. And we're going to talk about the various federal laws that apply at different stages of that life cycle. And in many cases, multiple laws apply at the same time. And then we're going to go through some scenarios and some frequently asked questions. And then, as I said, we're going to save time for some questions from you at the end. Again, we want to be able to recognize the interplay of the different laws and agreements that apply in this context. And we want to give you a better understanding of the kinds of data sharing and the types of disclosures that are permissible using student financial aid information under federal statutes and regulations. Some of the common questions that we're going to provide answers to today. Can I use financial aid information to generate and publish aggregate descriptive statistics? Can I evaluate university policies and programs using students' financial aid data? Can I use financial aid information to recruit a student who has not yet enrolled or who has not yet tried to enroll at the institution? And can I use that information to determine if a student who qualifies for a housing fee deferral pending financial aid disbursement? Also, we'll talk about who can you share financial aid information with. Can you share it with your university's institutional research office? Can you share it with your Board of Regents or Post-Secondary Higher Ed Commission? Can you share it with external researchers? And can you share it with third-party scholarship providers? So we're going to talk about all of these today, and then we'll talk about whatever additional questions you have, either on the intersection of these laws or on, if you have FERPA questions, those I can probably give you more definitive answers to, because that is run out of my office. So with that, I'm going to turn things over to my colleague Benjamin, who's going to walk you through the financial aid data lifecycle and the various laws that apply.
Thank you. So when we look at the flow of financial aid data, everything starts with the FAFSA, right? Parents and students sit down, they fill out the FAFSA, they send the application to the department. Once the department receives the FAFSA, we take the financial aid information from the FAFSA, process it into the institutional student information record, or ISIR. This ISIR data is then provided to the institutions, who add to the financial aid data that they receive from the department with the data that they collect on the students, and enter that information back into the National Student Loan Data System, or the NSLDS. School institutions can pull information from the NSLDS, as well as provide information to it. And the NSLDS feeds information back in to the ISIR. So let's move on to the applicable laws and agreements. As Mike already mentioned, we have the Family Educational Rights and Privacy Act, FERPA, the Higher Education Act, the HEA, the Privacy Act, and our only agreement, which is the Student Aid Internet Gateway Agreement, or the SAIG agreement. As we review these laws and agreements, it is important to remember that each of these laws, each of these laws impose unique restrictions on the use of financial aid data at different stages in the information lifecycle. And it is very important, as we're reviewing these laws, to remember that in instances where more than one law or agreement applies, the most restrictive provision from each law will apply jointly. And this can be confusing because of the intersection of all of these laws and at the different stages of the data life cycle. But don't worry, because we're from the government and we're here to help. So let's talk about FERPA. What is it? Well, the Family Educational Rights and Privacy Act applies to all institutions receiving federal funds under any program administered by the Secretary of Education. This includes programs like Title IV aid. Some financial aid data is therefore covered by FERPA, but we'll go over that in just a little bit. FERPA gives parents and eligible students the right to access and seek to amend their children's education records. And an eligible student is any student who is over 18 years old or a student who is in attendance at a post-secondary institution. So for the purposes of today's discussion, whenever Michael and I use the term student, what we're really meaning is eligible student, because this is a post-secondary audience. FERPA also protects personally identifiable information, or PII, from education records from unauthorized disclosure. And I'll cover both those definitions on the next slide. FERPA also requires written consent before sharing PII unless an exception applies, and we'll go over some of the most commonly used exceptions for financial aid data use as well. So PII, personally identifiable information. FERPA defines PII as information that is linked or linkable to a student that would allow a reasonable member of the school community to identify that student with reasonable certainty. This is a fairly broad definition. It includes direct identifiers like student names and social security numbers. It can also include indirect identifiers such as demographic data or course enrollment information. Education records under FERPA are those records that are directly related to a student and maintained by an educational agency or institution. So how does this apply to financial aid data? Well, FAFSA data, I think we all can agree, certainly contains PII. And if you remember back to our graphic, once institutions receive that ISER from the department, that includes the FAFSA data, they are maintaining that record. And once the student is enrolled at the institution or in attendance at the institution, it is directly related to a student, and therefore that FAFSA ISER data becomes an education record and is protected by FERPA. Like I said, FERPA requires written consent in order to disclose PI from education records, unless an exception applies. So we'll go over some exceptions now. And as you can imagine, the financial aid exception is probably one of the most commonly used exceptions when disclosing financial aid data from education records. This exception has very specific requirements for when it can be used. It must be for one or more of the following reasons: specifically to determine the eligibility for the aid, determine the amount of the aid, determine the conditions for the aid, or enforce the terms and conditions of the aid. Another commonly used exception is the school officials exception. This exception permits schools to disclose PII from education records to third parties providing functions or services for the school if those third parties perform an institutional service or function for which the agency or institution would otherwise use employees, are under the direct control of the agency or institution with respect to the use and maintenance of education records, only use PII from education records for the purposes for which the disclosure was made, and meet the criteria specified in the institution's annual notification of FERPA rights. It is the responsibility of each institution to establish criteria defining who is considered a school official and what constitutes a legitimate educational interest. These criteria may differ from school to school, but the criteria for both must be published in the school's annual notification of FERPA rights. The next exception is the audit and evaluation exception. This exception allows PII from education records to be shared without consent for certain audits and evaluations with authorized representatives of certain FERPA-approved entities, including state educational authorities. While individual institutions of higher education are typically not considered educational authorities under state law, it is common for states to establish a post-secondary educational authority, such as a higher education governing board, a board of regents, or a similar entity, to evaluate post-secondary education programs within the state. These entities are considered educational authorities under FERPA. Access to such PII may only be given to authorized representatives of educational authorities in connection with an audit or evaluation of federal or state-supported educational programs, or for the enforcement of or compliance with federal legal requirements that relate to those programs. Unless the authorized representative is an employee of the state or local educational authority, there must be a written agreement in which the authorized representative has been so designated. The last exception we're going to look at today is the studies exception. Under the studies exception, an institution may disclose PII from education records for studies that are for or on behalf of schools, school districts, or post-secondary institutions, if the studies are for the purpose of developing, validating, or administering predictive tests, or administering student aid programs, or improving instruction, and there is a written agreement with the individual or organization performing the study that meets certain requirements. These requirements for written agreements for both the studies exception and the audit and evaluation exception are on our website, so take a look at those if you have a chance. And these are only 4 of the 17 exceptions under FERPA. We have a lot of resources on all of them at our website, so please do take a look at those because there are others that could apply to financial aid data use. The next statute we're going to look at is the HEA, or the Higher Education Act. The HEA is the federal law that governs the administration of most federal student aid or student financial aid programs. The provisions of the HEA apply to information collected or derived from the FAFSA and to data included in the National Student Loan Data System, including data on the ICER from the NSLDS. But the HEA places additional unique provisions on NSLDS data. Privacy laws commonly establish protections in one of two ways. Some control access, and some control use. Some privacy laws establish controls for both. The HEA is an example of a law with strict use restrictions. Section 483A3E of the Higher Education Act restricts the use of FAFSA data to the application, award, and administration of Title IV aid, state aid, institutional aid, and aid awarded by entities designated by the Secretary. The Department has interpreted the administration of aid to include audits and program evaluations necessary for the efficient and effective administration of those aid programs. The HEA also prohibits non-governmental researchers and policy analysts from accessing personally identifiable information from the National Student Loan Data System and prohibits the use of NSLDS data for marketing purposes. Michael will give some common scenarios for what this means later on. The Privacy Act governs the collection, maintenance, use, and disclosure by federal agencies of records contained in the agency's system of records. Both FAFSA and NSLDS data are protected by the Privacy Act. The Privacy Act prohibits federal agencies from disclosing records from their system of records without prior written consent of the individuals to whom the records pertains, unless the disclosure is for a specified routine use or it is to a recipient who has provided written assurance that the record will be used solely for statistical research or reporting, and the record is to be transferred in a form that is not individually identifiable. So the Privacy Act applies to federal agencies. The SAIG is, or the Student Aid Information Gateway Agreement, is how the department meets its responsibilities under the Privacy Act. The department enters into the SAIG agreement with institutions to establish the conditions and safeguards under which the department provides institutions with the department's Privacy Act protected student financial aid data. All uses must be consistent with this agreement. Under the SAIG agreement, access, disclosure, and use of data is limited to authorized personnel. The department interprets authorized personnel to include individuals in your own institution, but also, when appropriate, individuals outside your institution who are permitted access to the information under all applicable statutes and regulations. So, like I said before, in instances where more than one law or regulation applies, the most restrictive provision from each law will jointly apply. And I think it would be helpful for us to maybe go back and look at our graphic here again. I'm a visual learner, so we can kind of look at and see how these statutes and agreements apply throughout the life cycle. So, mom and dad, son and daughter sit down, they fill out the FAFSA, they send it to the department. As soon as we receive it at the department, the Higher Education Act applies because it is the federal law that governs Title IV aid. The Privacy Act also applies because once the department receives the data, or the FAFSA, we take the information from the data and put it in our system of records as we process it into the ICER. So at this point, only the Higher Education Act and the Privacy Act are applying. Now, once the department sends the FAFSA data or the ICER to the institutions, the HEA continues to apply. It follows the information. The Privacy Act stays with the department, but the SAIG agreement is implicated in order for the institutions to receive the information. And once the student is in attendance at the institution, then FERPA applies. So we have the SAIG, we have the HEA, and we have FERPA protecting the information. As the school adds to the information that's received through the ICER, that data continues to be protected by the HEA and FERPA. And when the department when the institution enters the information into the NSLDS, the protections from FERPA, the HEA, continue to apply, and the Privacy Act is once again implicated. And those protections, the FERPA protections specifically, continue to follow that data as it is included in the ICER. So we will have instances where there'll be information in the ICER that is protected by FERPA, the Privacy Act, and the HEA. And with that, I will hand it back over to Michael.
Thank you, Ben. So clear as mud, right? As I said before, this does get very complicated very quickly when you're dealing with multiple statutory protections all applying at once. So let's walk through some scenarios and see if we can kind of see how these laws apply in different common situations. Now, I will apologize in advance. I normally hate to read notes as I'm giving a presentation, but because of the complexities here, you will see me consulting my notes just to make sure I'm not saying anything incorrect. So bear with me as I do that. So our first scenario, can an institution generate and publish de-identified aggregate statistics using FAFSA ICER data about students that are receiving financial aid at the institution? Quick show of hands, how many of you say yes? How many of you say no? Okay, so the answer is yes. The department considers the production of de-identified aggregate descriptive statistics about your financial aid programs to be part of the effective administration of a financial aid program. So let's look at how the different laws apply in this situation. So the HEA is the obvious one. The HEA restricts use to the application, award, or administration of Title IV aid, state aid, institutional aid, or aid awarded by other institutions that the Secretary designates. In the case of institutional aid, at your own institution, as I said before, the production of these descriptive aggregate statistics about your program is part of the effective administration of your aid program. So generation of these descriptive statistics in a de-identified form is permissible under the HEA. What about FERPA? So remember, FERPA protects PII from students' education records from disclosure. Well, in this case, as long as you're properly de-identifying the information, as long as you're properly de-identifying those aggregate statistics, well, then they don't contain PII anymore. So at that point, FERPA would cease to apply because you're not disclosing or publishing any identifiable information about those students. So it's permissible under FERPA. And lastly, as long as you're using the ICER information to produce these descriptive statistics, rather than pulling data directly from the NSLDS, then there are no additional Privacy Act provisions that apply. So Privacy Act isn't implicated, permissible under the HEA as administration of the aid program, and permissible under FERPA because it no longer contains PII. I do want to point out, however, all of this hinges on the proper de-identification of those statistics, making sure that they don't contain any student PII in them. Aggregate statistics can still be identifiable, so it does require some disclosure limitation techniques to be applied in the form of making sure that you have proper cell sizes or making sure that information about students can't be inferred based on how you're disaggregating those statistics by various identifiable characteristics like gender, race, ethnicity, and so on. So it's not just a simple matter of aggregating the numbers to de-identify them. You do have to go kind of one or two steps further to make sure that the data are properly de-identified. If you don't have any experience or if you need a refresher in statistical disclosure limitation techniques, we do have resources available on our website that can help you with that, and I'm also happy to answer questions on this. So our next scenario. Can a financial aid office share FAFSA ICER data with institutional staff who are responsible for analyses, audits, or evaluations at the institution? For example, an institutional research office. How many say yes? Okay, how many say no? How many say it depends? Okay. I will tell you one piece of information that will make you all experts in interpreting FERPA and other privacy laws. The answer is always it depends. It's always based on the context. So in this case, under certain circumstances, yes, you can. Under other circumstances, you can't. So let's look at how the laws apply in this context. So let's start with FERPA. As Ben mentioned, one of the exceptions to FERPA's consent requirement is disclosure to other school officials. Now, school officials with a legitimate educational interest can receive student PII without the student's consent. So in this case, disclosure to your institutional research office or other analysts within your organization would be permissible under FERPA to the extent that those individuals are considered school officials with legitimate educational interest by your institution. Now, if you remember from Ben's slide, these are terms that your institution defines in your annual notice of FERPA rights to students. So as part of that annual notice, your institution has to say, this is who we consider school officials, and this is what we consider legitimate educational interest. Now, those can be broadly worded. It doesn't have to be, I consider Fred, Jane, and Sarah to be school officials. It can be categories of individuals or types of use. But you do have to provide that definition in your annual notice, and any disclosure to individuals within your institution or to contractors and support personnel must meet that definition of school official with legitimate educational interest for this exception to apply. What about the Higher Education Act? Well, under the HEA, this disclosure to the institutional research office or others in the organization for analyses may be permissible to the extent that the IRO, the auditor or analyst, is performing a function, again, that is necessary for the efficient and effective administration of your aid programs. So essentially what this means is that analyses using those data that relate to your aid program, that relate to assessing, analyzing, administering your aid program would be permissible. But use by these other offices for purposes that don't relate to Title IV aid, state aid, institutional aid, et cetera, would not be permissible. So you couldn't use this information for something unrelated to the aid program. It would, under the HEA, need to be restricted to those permitted uses. Also, remember the provision with the NSLDS. If the data are NSLDS data, then it would only be permissible to the extent that the recipients of the data are considered governmental researchers or analysts. And so public institutions, that would certainly apply. In some other cases, that would apply. There may be restrictions if you're a private institution for disclosing NSLDS data to non-governmental researchers. So all of that said, it can be permissible in those circumstances. Disclosure for other purposes, however, would not be permissible. So, third scenario. Can an institution that is part of a public system of post-secondary institutions, think a university system, provide ICER data to their administrative central system-wide office or governing board, think your Board of Regents or your Higher Ed Governing Board or your Post-Secondary Commission, for an evaluation of the system's tuition and financial aid programs? How many say yes? Okay, how many say no? How many say it depends? Well, in this case, you're learning, but in this case, actually, it would be permissible. Let's walk through the laws. So let's start again with FERPA, because this is often a stumbling block when disclosing to outside entities. So as Ben mentioned, one of the exceptions under FERPA for disclosure of PII is to perform audits and evaluations by state or local educational authorities. Now, a state educational authority is any organization that is authorized under state law to evaluate and enforce education programs within the state. In many cases, a Board of Regents or a higher ed governing board or a post-secondary commission is designated by the state as a state educational authority. So provided that that kind of central coordinating office, that system-wide office, is a state educational authority under state law, then disclosure to that central office under FERPA is permissible because they are authorized under FERPA to receive the information to perform these audits and evaluations. Those audits and evaluations, again, have to be evaluations of a federal or state-supported education program. In this case, evaluation of the system's tuition and financial aid programs would constitute evaluation of an education program. So taken all together, disclosure to the Post-Secondary Commission, the Board of Regents, any of these institutions that are a state educational authority would be permissible under FERPA. Well, what about the HEA? So again, HEA restricts use to administration award and application administration award of Title IV aid, state aid, institutional aid, et cetera, to the extent that this is an evaluation of the system's financial aid programs that would constitute institutional aid or state aid or both. So that would be a permissible use under the HEA. And because the Central Coordinating Office are authorized by the state, they constitute government employees, they constitute government researchers, it would be permissible under that restriction under the HEA for NSLDS data as well. So in this case, HEA permits it, subject to those constraints. FERPA permits it, again, subject to those constraints. The Privacy Act would apply to the extent that you're pulling data directly from the NSLDS, but it does relate to the administration of the aid program, so it would be a permitted use under the SAIG because they are authorized under all relevant laws to receive it. Scenario 4. Can an institution use financial aid information provided by the student on the FAFSA to recruit a student who has not yet enrolled or tried to enroll at the institution? So they filled out the FAFSA, they haven't yet applied to your school. Can you use their financial aid information that was sent via the ICER to reach out to the student and try to convince them to apply? I'm hearing lots of mumbling. How many say yes? How many say no? Okay. Well, again, in this case, the answer is yes, subject to some constraints. So if the prospective student elected to have his or her FAFSA information sent to the institution's admissions office can have the information and may contact the student about the application and admission process. The financial aid office may use the student's financial aid information provided by the student on the FAFSA to communicate proposed financial aid award information. So permissible under the HEA there, because it's about the application, award, and administration of the aid program. What about FERPA? Is it permissible under FERPA? Doesn't apply yet. Good, you guys are paying attention. I like this. So remember, FERPA doesn't apply until the student enrolls at your institution, until the student is in attendance. So because FERPA isn't protecting those records yet, you don't have to worry about the FERPA exceptions. So between those two, permissible under the HEA, you're not pulling the data directly from NSLDS because it's coming via the ICER. Permissible under the HEA, FERPA doesn't apply. Yes, you may use it for those purposes. Scenario 5. Can an institution's housing office obtain FAFSA or ICER data to determine if a student qualifies for a housing fee deferral pending financial aid disbursement? How many say yes? How many say no? Okay. Well, again, this is a case where it can be permissible. Under the HEA, this disclosure would be permissible to the extent that the information is related to the effective and efficient administration, or in this case, disbursement of the institution's financial aid. So it can be permissible under HEA, subject to that use restriction. Under FERPA, it can also be permissible, again, to the extent that the staff in the housing office are considered to be school officials with legitimate educational interest. So again, this relates back to how your institution has defined school official and defined legitimate educational interest in your annual notice of FERPA rights. But if that use, if that disclosure is covered under that annual notice definition, then it would be permissible under FERPA as well. And again, since this is the ICER data and it's not being pulled directly from a department system of records, additional Privacy Act restrictions don't apply in this case. So yes, you may do so to the extent that it relates to the disbursement of aid. Scenario 6. Can an institution provide de-identified student financial aid data that's obtained directly from the NSLDS to a researcher not affiliated with the institution? So this is a tricky one. How many of you say no? How many of you say yes? Okay, and the rest of you are, it depends, I'm assuming. Okay. So this, again, is a case where it is actually permissible under certain circumstances. But there are a lot of requirements and documentation steps that would need to be met. So let's walk through this. Again, you have to look at how does the Privacy Act apply, how does FERPA apply. Under certain circumstances, an institution may provide de-identified student financial aid data that is obtained directly from the NSLDS to a researcher that is not affiliated with the institution for statistical research purposes. The Privacy Act permits the non-consensual disclosure of records to an individual who has provided the department with written assurance that the records will be used solely for statistical research purposes, and that the records will be transferred in a form that is not individually identifiable. Both the institution's written assurance that the data have been properly de-identified before being sent to the researcher, and the researcher's written assurance that the data will only be used for statistical purposes must be sent to the department. You can send it directly to PTAC, and we'll provide the contact information on a later slide. So both of those written assurances need to be sent to PTAC before disclosing a student's financial aid data that's pulled from the NSLDS or another department system of records without the student's consent. FERPA, if you look at the FERPA side, FERPA permits institutions to disclose these de-identified data, assuming that they have been properly de-identified, again, because there's no identifiable information, therefore the FERPA restrictions stop applying once it's de-identified. So yes, with certain restrictions and certain written documentation provided to the department, yes, you may do this. I do suggest for this one, because of the complexities and because of the documentation requirements, if you're looking to do this, definitely check out the description of this in our guidance document. It walks through all these steps in a little bit more detail, so definitely check that out. It's on page 8 of our guidance. And lastly, can an institution provide FAFSA ICER data to third parties? For example, scholarship organizations, state assistant agencies, and others. How many of you came to this session specifically because of this question? Yeah. I am sad that I'm going to disappoint you ever so slightly because I cannot give you a definitive answer on this today. I know, I feel bad. You're sharpening your pitchforks right now, I'm sure. So this is a really tricky question. We've actually received, at PTAC, we've received over 100 inquiries on this specific question, various permutations of it over the past few months, and more of them are coming in every day. I'm sure some of those inquiries have come from the people sitting in this room. So I'll tell you what I can tell you, and then I'll tell you that we're working on it. So as I mentioned earlier, under the Higher Education Act, Section 483A3E restricts the use of FAFSA data and any data derived from FAFSA data to the application, award, and administration of Title IV aid, state aid, institutional aid, and aid awarded by entities designated by the Secretary. The use restrictions in this section of the HEA does not contain any provision for students to consent to have their data used for any other use that is not listed in that section. Though it has come to our attention that many institutions have, until now, been operating under the assumption that students could consent to disclosures to these third-party organizations. So NASFA included this legal analysis of the use restrictions and the consent issue in their June 2017 white paper. And they reached out to us afterwards, and we did confirm that their analysis was correct. Since then, we have heard from a lot of you. I've heard from a number of colleges and universities, from third-party scholarship providers, and from others about the impact that compliance with this HEA restriction may have on students' access to financial assistance. We are actively investigating the issue, and we are evaluating a variety of possible options for equitable resolution of the challenges that this may pose to students' financial assistance. We do appreciate your patience as we work through this. We definitely welcome any questions or comments or insight from you, or any other information that you may have that can help us on this regarding the issue. We hope to resolve it soon, and once we do, we will broadly communicate any information through our website, through our listserv, and through other channels. If you want to stay kind of at the forefront of any developments on this issue, I do highly suggest that you register for the PTAC Student Privacy Listserv. You can sign up via our website, studentprivacy.ed.gov. We don't send out very many messages on that, usually around one a month or so no worry about spamming you. But if and when we come to a solution on this issue, we will be announcing it via our listserv, so that will be one of the easiest ways to get updated information. So, before I move things on to questions, I want to kind of end with a recommendation. We talked about the various restrictions on use of information that are imposed by various federal laws and how many of these laws apply at the same time. So your first step when looking at any proposed novel or new data use or data sharing arrangement should be, is it permissible? Can I do this? Is it allowable under all of the relevant laws that apply jointly? But that's not the end. Just because you can do something doesn't necessarily mean that you should. That compliance with the law is the floor. It's the bare minimum that you have to do. You have to comply with the law. There are a whole lot of data uses, a whole lot of data sharing arrangements that are permissible under the law, but that aren't a terribly good idea. So compliance with the law is your starting point, but then you should ask yourself, okay, I can do this. Should I do this? Ought I do this? And this is where you have to look at kind of, well, what is the student going to get out of this use? Remember that any time that we are holding students' personal information, we are stewards of that information, and we have a responsibility, all of us have a responsibility, to protect that student's privacy. That includes compliance with the law, but it's more than that. So think about, like, okay, what is the student going to get out of this, either directly or indirectly? And allow that to influence your decision of, okay, is this a good idea? Should we be doing this new use? Should we be doing this new data sharing arrangement? And only if you can answer, yes, this is the right thing to do, then move ahead. So definitely kind of evaluate both the legality of your data uses and the appropriatenesses of them. So also, we've seen over the last few years a tremendous proliferation of state privacy laws. Most of those privacy laws in the states are restricted exclusively to K-12 institutions, but increasingly we're seeing provisions in those laws that also apply at the post-secondary level. So definitely check out your state privacy laws, talk to your counsel, see if there are additional restrictions or requirements that your own state privacy laws are applying on top of the federal requirements that we've already talked about today. So I mentioned the Privacy Technical Assistance Center is a great resource for you and your institutions to learn more about how to protect student privacy, how to comply with the law, how to protect data security and the integrity of your data systems. We've got a wide variety of resources available, issue briefs, guidance documents, white papers, FAQs, case studies, training videos. We do targeted outreach. We can do in-person trainings, resources permitting. We do conferences. We have YouTube videos on commonly requested topics. We also operate a student privacy help desk. So if you have questions that the resources that we have online don't provide you with a sufficient answer to, or if you have unique circumstances relating to a particular student privacy issue, reach out to our help desk, and we've got a team of folks who will walk through your question with you and help you come up with a complete and thorough answer. A few of the resources that relate to what we've talked about today that you might want to check out on our website. Again, the January 2017 guidance that I mentioned that covers much of what we were discussing today. We had 2 letters on the use of financial aid information in 2016 that are very relevant to this discussion, our letter to Suffolk University and our letter to the University of North Carolina. We have guidance on how to protect privacy in data that you're publishing or data that you're releasing publicly, on disclosure avoidance and de-identification. And then there's 2 here from FSA, our Dear Colleague letter on the SAIG agreement and our Dear Colleague letter on FAFSA completion, both of which are also relevant in this context. Here's the contact information for PTAC and for the Student Privacy Help Desk. Again, this website at the bottom, that's where you can sign up for our listserv if you want to stay informed of new resources, new developments on that HEA use restriction issue, and also our email address, privacyta@ed.gov, if you have questions that you would like an answer to. And with that, on the subject of questions, I will open the floor. But please remember, and don't be upset if I can't answer all of your questions today, but we are taking note of them, and much like we took the questions we couldn't answer at last year's conference and included them in this guidance, we will take your questions today and hopefully include those and answers to those in our upcoming iterations of the guidance in the future. So with that, let's have question number 1.
So, hypothetically, if a state decided that the disclosure information on studentloans.gov was not sufficient and decided that they would require their schools to provide students with annual updates to their borrowing information, which would require NSLDS data to do this each year. And the schools were like, well, that would require amortization tables to give an estimate of the monthly repayment amounts, total borrowing, a percentage that you've borrowed, like say, okay, you've borrowed 68% of your lifetime limit on your direct loans or your Perkins or whatever the heck it is. So if a state did that and said, the schools shall do this, and you will provide it to the student once a year, and the school said, that's really complicated, maybe we could, get an organization to do this for us, like hypothetically some existing Great Lakes people or Sally Mae or somebody like that. Would it be permissible to get those folks to provide that information to the student via secure web portal kind of a thing? Could the school enter into an agreement to get that done under these applicable laws? All this is all hypothetical, of course.
So I cannot give you a complete answer to that because I would need to go back and check with our HEA attorneys. I can tell you from the FERPA side, it would likely be permissible under FERPA under the school official exception. So remember, you have to look at the most restrictive provisions of each law.
Yeah, the privacy one with the NSLDS data download was where I was
worried
about.
So the HEA and the privacy, that's the Privacy Act. Those are ones that I cannot give you an answer for today, but we have written your question down, and we will look into it and provide an answer.
Thank you.
Yes, sir.
Yes, I'm interested in whether we can reveal aggregated third-party information that is not related to a student's FSA information directly, that it's because of their situation, aggregated situation, that other studies might be done, and then can we reveal that information?
So my question to you would be, what kind of third-party information are you talking about? Because I think a lot will depend on the context there.
For example, their adverse childhood experiences survey scores, aggregated, their retention, their, resilience scores.
Okay, so none of this is financial aid information, correct?
No, but because of their situation, i.e. they're poor, that's why this data is being collected.
Okay, so the question would be if it's just FERPA protected, meaning that there's no FAFSA information or derived information included in that, then the FERPA rules would apply, because I'm assuming it's directly related to the student and it's maintained by your institution. Then they would be education records. You would have to properly de-identify them or have student consent. But to the extent that there is financial aid information kind of indirectly linked to the data, you'd have to look at, okay, who's collecting it? Like, how are you identifying the students that are going to be providing this information? And is their FSA data essentially implicitly included because you've only targeted those students? So it's a little bit more complicated than that. If it was just FERPA protected information, you could do it either by properly de-identifying it or by obtaining student consent or by following one of the other exceptions.
How about with the protection of an institutional review board?
So institutional review boards are a fantastic question. Institutional review boards are required under the Common Rule for the Protection of Human Subjects Research. Most institutions, most post-secondary institutions have them if you are engaging in research. Institutional review boards are concerned with confidentiality of information under the Common Rule, but generally do not evaluate proposed uses of information for compliance under other privacy laws. So they generally don't review proposals for FERPA compliance or HEA compliance. So that would be two different steps that you would have to go for there. You would need to make sure that it's compliant with FERPA, HEA, et cetera. You would then, if it's subject to the Common Rule as research, then you would need to have your institutional review board approval as well. That would be two different layers of protection.
Thank you.
Hi. Sorry.
Hang on one second.
I was wondering, the gentleman who asked the first question, just if you would mind coming up after, because I have some follow-up questions for you.
Okay. Yes, ma'am.
So my question, I think, is just related to the one you asked. So if the, not necessarily collection, but say an agency, internal or external, was doing evaluation or research for an institution, the outcome of which was determining student success factors, not necessarily the effectiveness of the financial aid program, but why are they leaving, why are they staying, and what can we do better to support them? How does that, how is that okay?
So that's going to be, I think,
But financial aid data is part of this analysis.
the answer to that's going to be it depends, because you can't avoid the use restriction. So it has to be for the permitted uses under the HEA. So there are some proposals, like some research questions, for example, some analyses that relate to what you're talking about that I think could fall within administration of the program. I think there are many that probably wouldn't. And so a lot of it's going to be looking at specifically what are you doing and how closely does it tie back to the aid program.
Yeah.
So I can't give you a definitive answer without knowing more about like the specifics that you're looking at.
Yeah, like you, Ted here said it would be kind of like evaluating your SAP policy, but SAP has, satisfactory academic progress has implications on whether or not they can continue to get aid. This research I'm talking about would be, hypothetically, only for student success evaluation.
I have a friend.
Yeah. You know, like what kind of non-financial support can we give them? But you're saying somehow it kind of needs to tie to your financial aid program.
Right, you have to meet that use restriction.
Right.
And so if the work meets that use restriction and meets all the other requirements, then it would likely be acceptable.
Okay.
But again, you have to be able to tie it back to the permitted
Right.
uses under the HEA.
Okay, thank you.
If you want more detailed, if you want to talk in more depth, reach out to us and we can talk through the specific analyses that you're proposing and give you a more definitive answer. Yes, ma'am.
Hi, good morning. Question about Student Advancement Office our advancement office that wants specific information on our enrolled students about their family income and employment information so that they can start nurturing relationships early.
Okay, so I'm unfamiliar with the term Student Advancement Office.
Oh,
Can
the
you-
fundraisers.
Oh, okay. I'm well familiar with them, yeah. I get calls every other week from my various alma maters. Generally speaking, there would be a number of impediments to that.
And I've told them no to this
Yeah,
point.
like there's impediments under FERPA, there'd be impediments under HEA. I don't want to give you a blanket, no, it can never be done, because
I'm fine if you
there's-
do give me that blanket.
there's-
no. We
there's-
can
there's-
keep it in this room.
There's always unusual
Like,
situations.
no tweeting, put your phones down.
There's always unusual situations that, like, I've learned never to give definitive answers on things, because somebody will turn around and is like, well, what if you do this and this and this other thing? And I was like, okay. But generally speaking, that I don't see how that would be permissible under the laws.
Thank you.
Yes, sir.
Okay, you may not be the right people to ask this question, but who is Recorded Future, and how do they know about a data breach that no one on my campus knows about?
So I have no idea who Recorded Future is, but data breaches, we actually look a lot at data security issues on my team, and there are a number of ways that third-party organizations could know about breaches that you are unaware of. It could be that if it was a malicious breach, like a hacker, it could be that they were bragging about it there's a number of kind of dark web communities where these things are discussed, and hackers like showing off what they've done. It could be that information that was exfiltrated from your systems showed up for sale somewhere. It could be that somebody found the information online. So there's a variety of ways that people can find out without your institution knowing about it, but I don't know this particular group or how they found out about your breach.
Wouldn't it be helpful for the department to kind of give us a little more clue than Recorded, what's the name? Recorded Future has reported that you have, like, give us a day, a month, a year. I assume the year is this one, but.
More information is always useful. I don't know who sent you that, but I can certainly talk with my colleagues and try to make things more helpful.
Okay.
Yes, ma'am.
Okay, I'm a little confused. The slide that you said you really didn't have the answer to about releasing information to scholarship and state authorities. Those of our students who bring in the disclosure form signed for social service agencies, is that included in that? Because the form that they bring in has their authorization for us to give, but they won't keep their social services or doors or those things until we fill those things
Okay.
out.
I cannot give you a specific answer to your specific question today. What I can tell you is, so again, when multiple laws apply, the most restrictive or specific provisions of each apply. One thing that we only touched on in the FERPA section of our presentation today that does come into play here, but again, the specifics are still, I can't discuss the specifics, but one of the provisions there is front and center of a student's rights under FERPA is their right to access their own information. The use restrictions of the HEA do not preclude students from receiving their own education records. To the extent that their financial aid information is included in their education records, students have an affirmative right to receive that information, to be able to access that information. What that means in the context of like the forms that you're talking about, I can't give you a comment today.
Well, I guess that's my concern. I didn't know whether this also related to that because the students bring us the forms, but the forms are then sent to the agencies.
By you?
Yes.
Okay, so that would be a use that would not be consistent. Unless the use by the agency constitutes Title IV aid, state aid, institutional aid, or aid by an other entity designated by the Secretary, your institution cannot do that under our current understanding.
Well, so should we be giving it back to the student?
I cannot comment on that.
Okay.
A student has a right to their own information under FERPA.
And they can do with it what they please.
A student has a right to their own
Okay.
financial information under FERPA.
Okay.
And we are not going to tell a student that they can't do something with their own information. I will tell you that. Yeah.
And same thing with students who apply for scholarships and ask us,
A student can get their own information and they can do whatever they
Okay.
want with it.
and the reason I'm asking is because in years past, that is what happened. The students were given the information to take back. Because of electronics and all, and the fact that agencies think students may be altering information, they want it directly from the institution so they know it's correct.
We have heard that from a number of organizations, and that is something we're looking into.
Okay, so keep
Yeah.
looking.
Sign up for our listserv, and once we have more information, we will provide it. Yes, ma'am.
So I understand how this applies to FAFSA information. If we're a profile school, how does that change with what we can do, whether it's providing to other agencies? So we're taking the information that they provided through their CSS profile, not their FAFSA.
I am not familiar enough with the details of profile schools to be able to give you an answer on that, just because
Okay.
I work on the privacy side of the house. I
Okay.
like the ins and outs of the complexities of these things are not front and center in my own expertise. But if you send your question in to us,
Okay.
we can get the right people together and get you an answer.
Okay, and then just real quick, McNair grants, so federal grant program. So we are asked by the offices that manage the grant to send them a list of students that meet certain requirements, income requirements, eligibility. That's what they want, so they can then basically solicit those students to receive the grant funding.
Who administers McNair grants?
Usually it's like a faculty department. I mean, it depends on each campus.
But like where's the funding coming from?
It's from the government.
But like which agency?
Anyone know? Okay. Title III.
Okay, so that is something I will have to look into.
Okay.
Yeah, but you
All right.
send that in with your other question, and
Okay.
we'll answer that as well.
All right, thank you.
We're having, like, there's a number of other government agencies that have been caught up in this as well, and we're working with them on solutions to this challenge as well. So, yes, sir.
Just a quick comment on that. Profile data is a separate financial aid application form. It's subject to FERPA because it's educational records if the student's enrolled at the school. It might not be subject to the HEA restrictions because it's not coming from the FAFSA. So they might actually be able to share that, but there are only about 200 profile schools.
Okay. Again, I'm not familiar with the program, so.
Right. My question is, first question is, I was a little bit surprised by your statement that the school can use FAFSA data for recruiting purposes. Now, FERPA doesn't apply because they're not yet a student, but the HEA restrictions are on the use for financial aid and efficiency. Admissions is neither of those. And in fact, my understanding was that the justification for the department no longer sharing the list of colleges on the FAFSA with the colleges was because it was being used to influence admissions decisions.
I will tell you that,
Scenario 4.
yeah. We analyzed this on page 9 of our guidance, and it was reviewed by all of the relevant programs and attorneys at our department. So to the extent that the use is consistent with what's written in the guidance there, it is permissible under current understanding.
And is there an ETA on the resolution of the scholarship provider situation?
I learned many years ago never to promise timeframes with anything relating to government work, but rest assured that it is something that is at the very top of our list of priorities, in my office anyway. This is something that we know has substantial implications for students, and we want to come to a resolution on this. I can't give you a time frame, but know that it is one of our high priorities.
Thank you.
Yes, sir.
The website link for you has an extra period in it between student and privacy, so it's
Oh.
not linked correctly in there.
Okay, I'll
for
see if I can
anyone
get
that's
that
gonna-
fixed. Thank you for pointing that out.
So yeah, on the same scenario 4, the thing that I'm finding difficult is that you're distinguishing the purpose for the admissions office to use that PII is for the recruitment of students. But under the other exceptions, is it allowable for the admissions office or, say, the athletics office to recruit students using Pell eligibility to determine scholarship information for that student?
Sorry, I missed something in your question
Well,
there. So.
Outside of our office, which would generally determine scholarship eligibility, is it permissible for other areas of our university to determine scholarships for a student in the recruitment part? So our athletics office might want to know about a student's EFC so that they can determine what scholarship to offer that student relative to how much Pell they're receiving.
So I can't give you a definitive answer on that because I'd want to check with our attorneys, but to the extent that these uses would relate to institutional aid, like award of institutional aid, it would appear to me that that would be permissible. But I'm going to caveat that with that's something I would need to go back and confirm.
Okay. And then in terms of scenario 7, it looks like it's not referring to any page in the PTAC. And
Yeah, because it's the unanswered question.
but the last question in the PTAC guidance is very similar to this one, and it seems that you're saying no in it. And maybe I'm relating them differently, but
The question that's in there was narrower than this. This is the broader question, and I did not include an answer here because this is also reflecting the legal developments and the new understanding of the use restrictions of the HEA that came to light after the guidance came out.
so it seems like there's a dialogue going on here.
Yes, there is a
And
dialogue
in
going
terms of the dialogue, I don't know if there's a place or a depository of all of the things different financial aid administrators are saying to you to say, here's my thought on it, and then I don't know what I don't know. I don't know what other suggestions schools have made or what arguments they've made to you. I'm curious what the strongest argument is that you've heard to make you think, well, I don't know, let's waffle on this one a little bit and see where we go with it because we're not really familiar to the extent that we should be with that answer.
So we have, as I said, we've received over 100 questions and inquiries on this topic over the past few months, not just from colleges and universities, but also from other federal agencies, from state aid agencies. We've been getting substantial amounts of information kind of from every side of this.
There's no public comprehensive list that we can access.
These are just like technical assistance questions that have been coming into us.
Okay. So,
But we are very actively reviewing all of those and taking that into account in our decision making.
my suggestion in referring to this specific scenario is I don't know how to properly determine estimated financial assistance to a student for the awarding of their Title IV aid if I'm not able to determine what their state assistance or their scholarship organizations are offering them. So as it relates to determining estimated financial assistance, it seems that we have a vested interest in knowing about their eligibility, which means certifying that they are eligible to a scholarship agency.
I recommend sending that into our help desk, and we'll include that.
Hi, 2 questions from my director, and I apologize if they're repetitive. Is Pell eligibility information, not the specific amounts, considered restricted information? It is not FAFSA data, but it is a result of FAFSA data. For example, on a study abroad scholarship application, say for a Gilman scholarship, it asks, is the student Pell eligible? Yes, no.
We have been in discussions with Department of State about this issue.
Okay. And then, thank you. And then finally, define financial aid data. Is this strictly the 100 plus questions on FAFSA and resulting EFC, or does it include awards made based on the data also?
Generally speaking, when we're talking about the HEA restrictions, we're talking not just about the information that's provided on the FAFSA, but any information that's derived from that. So any downstream information or transformations, calculations that are taken from those information.
Okay, thanks.
And we've got just a couple minutes left. Yes, sir.
Yeah, quick hypothetical question, I guess. So, and this is more, I think I know the answer, but if you say that I'm right, then that really helps when I go home. In our system, we have academic advisors that can see students' account information. In our system of record that we use, it'll display financial aid awards in that account system that are pending or have paid. These academic advisors have no process or duties at all in determining financial aid eligibility or awarding. Is it inappropriate for them to be able to see that a student has a Pell Award or any financial aid award specifics besides just perhaps their entire amount, but it allows them to defer
Yeah, so generally
information.
speaking, I'd give you two pieces of advice there. The first would be on the FERPA side. Does the advisor have a legitimate educational interest in having that financial aid information? Because it's part of their education record, but it can only be given to them if they have a legitimate educational interest in receiving it. So that would be your first question is it permissible under FERPA? And you'd have to look at what the advisors are using the information for and whether that's consistent with how your school has defined school official with legitimate educational interest.
Okay.
On the HEA side, you then also have to look, is the advisor's use of the information consistent with the use restrictions? Does it relate to the administration of an aid program? And there may be situations where it could relate, but there's also situations where it certainly wouldn't relate. So you'd have to look at how are they using that information.
On our campus, no.
Then in that case, it wouldn't be permissible under the HEA use restriction, and it probably wouldn't be permissible under the FERPA legitimate educational interest definition.
Okay. Second question, sort of related. We have a disaggregated, we have a group of students we identify. They are pulled into the group by either being Pell eligible or an underrepresented minority. Is that disaggregated enough with the financial aid aspect to make it permissible for advisors and other people that have nothing to do with the awarding of aid to work with the student group? The problem we have is that certainly if you are not a member of the underrepresented minority, it's very obvious you're in the group because you're Pell eligible and so you're low income. And that's our concern is that information with that
That's
use.
an excellent question, and it's one that I'd want to think about a little bit more. So if you could send that one in, that would be great, and we
Okay.
can look at it. And I am being told by our lovely room monitor that I have to stop right now. But if you have extra questions, we have another session this afternoon. You're welcome to attend that. Or you can send your questions in to our privacy help desk, privacyta@ed.gov. Thank you so very much.